The redistricting earthquake is spreading. Just when Democrats thought the damage from the landmark Calais ruling couldn't get any worse, the Supreme Court just dropped yet another bombshell that has Democrats, strategists, party leaders, and race-based gerrymandering architects absolutely panicking. The Supreme Court issued two major follow-up orders in the wake of the Calais ruling yesterday, and both of them are devastating for the Democrat Party's race-based redistricting machine. Now, the first case is out of Mississippi. A three-judge panel in the Southern District of Mississippi had sided with plaintiffs backed by the ultra-far-left NAACP, who claimed that certain state legislative districts diluted the black vote. Now, if you don't know what this vote dilution is a very creative gimmick that the far left came up with about 40 years ago to deliberately predetermine guaranteed Democrat seats. They exploited the notion that black voters couldn't get their preferred candidates into office as long as there were too many white voters in their district. So as to ensure racial justice, districts had to be redrawn so as to guarantee that black voters could elect candidates of their choice, i.e. Democrats. Otherwise, they're being disenfranchised, racially disenfranchised. And so this lower court actually ordered Mississippi to redraw its maps to address that alleged transgression, which is just code for you need to manufacture another guaranteed Democrat seat. It was a textbook application of the old pre-Calais Section 2 Voting Rights Act standard, the kind of judicial activism that Democrats have relied on for 4 decades to force the creation of majority-minority districts that deliberately discriminated against white voters. But yesterday, May 18th, the Supreme Court vacated that order and threw it out. In light of the Calais decision that officially recognizes such practices as blatant racial discrimination, Mississippi does not have to listen to that court order. The second case is out of North Dakota. The 8th Circuit Court of Appeals was examining a challenge to North Dakota's legislative districts, this time on behalf of Native American voters who claimed their political power was being diluted because of too many white voters. That's always the pretext there. So do you notice how voter dilution only ever applies to minority non-white voters, right? Never the other way around. Regardless, the 8th Circuit made an interesting but ultimately irrelevant distinction. It ruled that only the federal government can sue to enforce Section 2 of the VRA, not private parties. But the Supreme Court, again, wanted nothing to do with it. They vacated that ruling, sent it back for reconsideration in light of the recent Calais decision. 2 more lower court decisions vacated, gone in the same week, all as an open declaration that a new sheriff was in town. Calais is now the law of the land.